my buddy, Shipwrecked Crew, on the legal question of whether an Article 2 ICE officer is required to have a judicial warrant, not just an administrative warrant, but a judicial warrant signed by an Article 3 judge before the Article 2 ICE officer is legally permitted to non-consensually enter a private home to make an otherwise lawful arrest of an illegal migrant fugitive subject to a final order of deportation from our country. Presumptively law-abiding American citizens, generally, if a warrant is going to be used to enter your home, it needs to be an Article 3 judicial warrant. The Article 2 police officer who wants to enter your home against your will cannot simply issue his own warrant. We want a distance between the Article 2 officer who wants to enter and whoever it is that's going to sign the piece of paper, the warrant that legally justifies his entry. So we say that distance, so we have an impartial person involved. The Article 2 officer decides he'd like to go in against your will. He has to go to an Article 3 judge to review the warrant and decide that there exists probable cause or whatever legal standard might apply in the circumstances to justify the non-consensual entry. The Article 3 judge signs the warrant, and that gives an impartial justification for the Article 2 officer to then enter. But while this is a pretty well settled area of the law when it comes to presumptively law-abiding American citizens, it's much less settled when we're talking about people whose Fourth Amendment privileges might be somehow compromised. So certainly, as I said, a presumptively law-abiding American citizen is entitled to the full protection of the Fourth Amendment, and an Article 3 judicial warrant would be required for forced entry into that citizen's private dwelling, unless, of course, there were some other justification for entry. We'll circle back to that. But American law has long treated other classes of persons who are not presumptively law-abiding citizens, treated other classes of persons with less Fourth Amendment protection. People who are out on probation, who've been previously convicted of a crime, escaped felons who've been previously convicted of a crime, and other categories of people have a far more limited Fourth Amendment protection. Typically with those people, a simple Article 2 administrative warrant is sufficient to enter, and an Article 3 judicial warrant is not required. So the question now is, in the context of illegal migrants, does this more limited Fourth Amendment protection that applies to some people who are no longer presumptively law-abiding American citizens similarly apply to illegal alien fugitives who are subject to a final order of deportation, so that ICE can lawfully enter with a mere Article 2 administrative warrant instead of having to have an Article 3 judicial warrant? Again, I urge you to subscribe if this stuff is of interest to you. Bill does great work. It's not costly. I'm personally a paid member. So, is a warrantless entry into a residence to take custody of an illegal alien really a violation of the Fourth Amendment? There is no shortage of outraged voices on social media and the internet as a whole over the DHS ICE policy just released that allows officers with a final warrant of removal to enter a residence for the purpose of apprehending an illegal alien. Law professors, defense attorneys, civil libertarians, and just about every liberal progressive talking head who opposes the ICE enforcement policies of the Trump administration is screaming from the rooftops that when ICE forces entry, so it's non-consensual, you can always ask for permission. And if you're granted permission, obviously you don't need a warrant. When ICE forces entry into a residence to arrest an illegal alien inside, that this is a violation of the Fourth Amendment's warrant requirement and another step down the path from authoritarianism to a fascist state. But is it? Is it? This is how an actual properly functioning legal mind functions. Critical thinking, you might call it. The Fourth Amendment reads in its entirety, quote, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized," close quote. Bill writes, that seems pretty straightforward. The protections attached to persons, houses, papers, and effects. But then we have this, quote, the guarantee of freedom from unreasonable searches and seizures, and I presume he's quoting a U.S. Supreme Court decision here. Yes, Carroll v. United States. Quote, the guarantee of freedom from unreasonable searches and seizures by the Fourth Amendment has been construed practically since the beginning of the government as recognizing a necessary difference between a search of a store, dwelling house, or other structure in respect of which a proper official warrant readily may be obtained, and a search of a ship, motorboat, wagon, or automobile for contraband goods, where it is not practicable, I think will be a key term here, where it is not practicable to secure a warrant because the vehicle can be quickly moved out of the locality or jurisdiction in which the warrant must be sought. This is a booze case. Bill continues. So the warrant requirements does not apply to cars. The search or seizure of a car or its contents must be reasonable, but the warrant requirement doesn't apply. The above language is from Carroll v. United States, 1925, where the Supreme Court held that warrantless searches of automobiles did not violate the Fourth Amendment so long as they were premised on probable cause. Then we have Terry v. Ohio, another Supreme Court decision, the basis for what's called the Terry stop by police, 1968, quoting now from Terry, quote, there is some suggestion in the use of such terms as stop and frisk that such police conduct is outside the purview of the Fourth Amendment because neither action rises to the level of a search or seizure within the meaning of the Constitution. We emphatically reject this notion. Whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person. And it is nothing less than sheer torture of the English language to suggest that a careful exploration of the outer surfaces of a person's clothing all over his or her body in an attempt to find a weapon is not a search. The notions which underline both the warrant procedure and the requirement of probable cause remain fully relevant in this context. In order to assess the reasonableness, it is necessary first, to focus upon the governmental interest, which allegedly justifies official intrusion upon the constitutionally protected interests of the private citizen, for there is no ready test for determining reasonableness other than by balancing the need to search or seize against the invasion for which the search or seizure entails. We cannot blind ourselves to the need for law enforcement officers to protect themselves and other prospective victims of violence in situations where they may lack probable cause for an arrest. So you don't need probable cause for a Terry stop. You need reasonable suspicion. We must still consider, however, the nature and quality of the intrusion on individual rights, which must be accepted if police officers are to be conceded the right to search for weapons in situations where probable cause to arrest for crime is lacking. Our evaluation of the proper balance leads us to conclude that there must be a narrowly drawn authority to permit a reasonable search for weapons, regardless of whether the officer has probable cause to make an arrest. So some threshold that's less than that required for arrest. What do you need for arrest? Probable cause. What do you need for this kind of transient stop, search, and seizure? Is reasonable suspicion. So the search, Bill continues now, so the search of an automobile without a warrant doesn't violate the Fourth Amendment if there is probable cause to conduct the search. But the search of a person during a brief detention by a law enforcement officer doesn't even require probable cause, where doing so is a reasonable act to ensure officer safety. So that's two exceptions to the Fourth Amendment warrant requirement right there. But what about searches of a residence? In 1987, Justice Scalia wrote the majority opinion in the SCOTUS case of Griffith v. Wisconsin. Quote, a probationer's home, like anyone else's, is protected by the Fourth Amendment's requirement that searches be reasonable. Although we usually require that a search be undertaken only pursuant to a warrant, we usually require that, and thus supported by probable cause, as the Constitution says warrants must be, we have permitted exceptions when special needs beyond the normal need for law enforcement make the warrant and probable cause requirement impracticable. A state's operation of a probation system, like its operation of a school, government office, or prison, or its supervision of a regulated industry, likewise presents special needs beyond normal law enforcement that may justify departures from the usual warrant and probable cause requirements. A warrant requirement, Scalia continues, a warrant requirement would interfere to an appreciable degree with the probation system, setting up a magistrate, an Article III judge, rather than the Article II probation officer of the judge of how close a supervision the probationer requires. And that's an Article II function. Moreover, the delay inherent in obtaining a warrant would make it more difficult for probation officials to respond quickly to evidence of misconduct and would reduce the deterrent effect that the possibility of expeditious searches would otherwise create. Although a probation officer is not an impartial magistrate, neither is he the police officer. So there's not the same distance between an Article II police officer and an Article III judge as there is between a probation officer and a judge, but there's still distance. Sorry, the reverse of that. There's not as much different distance between a probation officer and a judge as there is between a police officer and a judge, but there's still distance. He is an employee, the probation officer, of the State Department of Health and Human Services. The applicable regulations require him, for example, to, quote, provide individualized counseling designed to foster growth and development of the client as necessary, close quote. In such a setting, we think it reasonable to dispense with the warrant requirement. That's the end of the Scalia quote from Griffith v. Wisconsin. Bill Shipley continues here. So the warrant requirement is dispensed with when the special needs of a government program are such that the effectiveness of the program would be undermined if the warrant requirement were applied. The decision to enter a residence and search based on reasonable suspicion may be made by someone who is not an impartial magistrate, but instead works for a state agency whose special needs are beyond the normal need of law enforcement. So what about immigration and ICE removal operations? Does the effective administration of our national immigration program involve special needs that go beyond the normal needs of law enforcement, such that the warrant requirement can be dispensed with, as was done in Griffith? Now, keep in mind, with Griffith, we do have a guy who's been convicted of a crime. We don't have that in the immigration situation, typically, right? I mean, if the person's been convicted of a crime, it puts them more fully into Griffith. But let's presume an illegal migrant fugitive with a final order of deportation whose only offenses have been civil offenses. Bill continues, there are two Supreme Court cases of interest to me that deal specifically with immigration and the application of the Fourth Amendment. In 1960, the Supreme Court decided Abel v. United States, which came to the court as an appeal of the defendant's criminal conviction for espionage as a Russian spy. The INS, working in conjunction with the FBI, took Abel into custody inside his New York hotel room, where it had entered without a warrant. And by the way, if you're in a hotel room, you have all the same Fourth Amendment protections as you do in your home. It's your transient domicile. It's your castle while you're living in it. When Abel declined an invitation, I guess there are caveats to that. The hotel personnel still have a presumed privilege to come in to inspect and clean and things along those lines. But they wouldn't be there to search for evidence like a law enforcement officer would. When Abel declined an invitation to cooperate with the FBI in its counterintelligence mission, I guess they offered to turn him into a double agent, INS stepped in and arrested Abel pursuant to an Article II administrative arrest warrant, and searched his room for evidence of his alienage, that he's not an American national. Here is how the Supreme Court described the episode. Quote, the FBI officer in charge asked whether the petitioner, Abel, was arrested. The FBI might interview him in an attempt to persuade him to cooperate with regard to his espionage. At 7 o'clock the next morning, June 21st, two officers of the INS, Immigration and Naturalization Service, and several FBI men gathered in the corridor outside petitioner's room at the Hotel Latham. FBI agents Gamber and Blasco were charged with confronting petitioner and soliciting his cooperation with the FBI. They had no warrant either to arrest or search. If petitioner failed to cooperate, they were to summon the waiting INS agents to execute their Article II administrative warrant for Abel's arrest. FBI agent rapped on the door. When Abel released the catch, the agent pushed open the door and walked into the room, a forcible entry, followed by the second agent. Although Abel answered some of their questions, he did not cooperate regarding his alleged espionage. A signal was sent to the two agents of the INS waiting in the next room. They came into the petitioner's room and served him with the Article 2 administrative warrant for his arrest. After placing petitioner under arrest, the four INS agents undertook a search of his person and all of his belongings. In the room, in the adjoining bathroom, which lasted from 15 to 20 minutes, petitioner did not give consent to this search. His consent was not sought. So not a consensual search. When the search was completed, almost everything in the room was packed into petitioner's baggage. When everything had been assembled, petitioner asked and received permission to repack one of his suitcases. While he was doing so, one of the INS supervisors noticed him slipping some papers into the sleeve of his coat. The supervisor, INS, seized these. One of them was the challenged item of evidence. We have designated a piece of graph paper containing a coded message. Now, Bill Shipley, prior to his trial, Abel had filed a motion to suppress that evidence, seized from his room on the grounds that the entire operation was a bad faith collaboration between the FBI and INS to seize evidence when the FBI lacked probable cause. The motion was denied, and this was one of the grounds raised in his appeal before the Supreme Court. On that question, the Supreme Court held, quote, "We've considered the case on the assumption that the conviction must be reversed should we find the challenged items of evidence to have been seized in violation of the Constitution and therefore improperly admitted into evidence." In other words, that they should have been excluded. We find, however, that the admission of these items was free from any constitutional infirmity, including Fourth Amendment infirmity, and we affirm the judgment, close quote. Bill Shipley now, neither the INS nor the FBI had an Article 3 judicial warrant to search or arrest when they entered Abel's hotel room. And yes, hotel rooms, he says, are treated the same as houses for the Fourth Amendment purpose. What INS did have was a Article 2 administrative arrest warrant and an order to show cause why he should not be deported, both signed by the New York City District Director of the INS, an Article 2 officer of the government. Abel had not challenged, as part of his criminal case, the constitutionality of the arrest process that did not comply with the warrant requirement of the Fourth Amendment. On that basis, the Supreme Court declined to consider such a challenge for the first time on appeal. But that didn't stop the Supreme Court from commenting on the administrative arrest process. Quoting the Supreme Court again, quote, "Statutes authorizing administrative arrest to achieve detention pending deportation proceedings have the sanction of time. We've been doing this forever. It would emphasize the disregard for the presumptive respect the Supreme Court owes to the validity of acts of Congress," he means laws, "especially when confirmed by uncontested historical legitimacy, to bring into question for the first time here such a long-sanctioned practice of the government," close quote. Bill writes, "This is only 1960. Much of the Supreme Court's modern jurisprudence on the 14th Amendment," sorry, I keep doing that. Bill writes, "This is only 1960. Much of the Supreme Court's modern jurisprudence on the Fourth Amendment begins in the 1960s. So it would be difficult for the critics of this Trump administration to dismiss Abel as relic that predates the Supreme Court precedent that governs most issues today." Actually, I think Bill may have miswritten here. I think he means to write, "So it would not be difficult. It would not be difficult." What he's trying to say here is this case was in 1960, but a lot of our search and seizure law happened after that. We had a different Supreme Court, the same Supreme Court that gave us things like Tennessee versus Garner, police use of force cases. It all happened, those cases happened in the 80s. So if there's old law that preceded that kind of change in the legal framework, you might argue, well, that old law, that's a relic. It doesn't apply anymore because the legal framework changed. So I think what Bill meant to write here is, so it would not be difficult for the critics of the administration to dismiss Abel as a relic that predates the Supreme Court precedent that governs most issues today involving search and seizure. But he quotes from the case again, quote, "The present form of the legislation giving authority to the Attorney General or his delegate to arrest aliens pending deportation proceedings under an Article 2 administrative warrant and not a judicial warrant within the scope of the Fourth Amendment is Section 242 of the INA. The regulations under this act delegate the authority to issue these Article 2 administrative warrants to the district directors of the INS. The arrest procedure followed in the present case fully complied with the statute and regulations. Statutes providing for deportation have ordinarily authorized the arrest of deportable aliens by order of an executive official. The first of these was in 1798. The constitutional validity of this long-standing administrative arrest procedure in deportation cases has never been directly challenged in reported litigation. This Supreme Court seems never expressly to have directed its attention to the particular question of the constitutional validity of administrative deportation warrants. It has frequently, however, upheld administrative deportation proceedings shown by the Supreme Court's opinion to have been begun by arrests pursuant to such Article 2 executive branch warrants, administrative warrants, close quote. Now, back to Bill Shipley. Now, he writes, it must be acknowledged that the Supreme Court's seminal case on the need for a warrant to enter a residence to make an arrest came in 1980, Payton v. New York. That's 20 years after Abel. So it can be argued that the tacit concession to the legality of the warrantless entry into Abel's hotel room would have been unlikely if Abel was revisited after Payton, the 20 years later case. But one thing to keep in mind about Payton, it represents one of the last dying gasps of the liberal Warren Burger Court's era. In the majority in Payton, written by Justice Stevens, were Justices Brennan, Stewart, Marshall, Blackmun, and Powell, with C.J. Berger and Justices White and Rehnquist dissenting. By the way, did you know that the case of Miranda, or the basis famously of our Miranda rights, you know that was a 5-4 decision by the Supreme Court? One justice switching would have been the opposite of that case. And the dissent, if you've never read Miranda, I would encourage you to read it, especially the dissent. They had very good reasons for why there ought not be a constitutional right to have rights read to a criminal suspect before questioning. In any case, back to this. Here is some of what the Supreme Court had to say in Payton about the warrant requirement to enter a residence. Quoting the Supreme Court in Payton now, quote, it's a basic principle of Fourth Amendment law that searches and seizures inside a home without a warrant are presumptively unreasonable. But the critical point is that any difference in the intrusiveness of entries to search and entries to arrest are merely ones of degree rather than kind. The two intrusions share this fundamental characteristic, the breach of the entrance to an individual's home. The Fourth Amendment protects the individual's privacy in a variety of settings. In none is the zone of privacy more clearly defined than when bounded by the unambiguous physical dimensions of an individual's home. A zone that finds its roots in clear and specific constitutional terms. The rights of the people to be secure in their houses shall not be violated. That language unequivocally establishes the proposition that at the very core of the Fourth Amendment stands the right of a man to retreat into his home and there be free from unreasonable governmental intrusion. And Bill comments, this is typical of Warren-era writing from a liberal justice like Stevens, overly dramatic expeditions of liberal shibboleths. Continuing with the Supreme Court now, it is true that an arrest warrant requirement may afford less protection than a search warrant requirement, but it will suffice to interpose the magistrate's determination of probable cause between the zealous officer and the citizen. So you have this impartial Article 3 judge standing between the cop and the citizen. Thus, for Fourth Amendment purposes, an arrest warrant founded on probable cause implicitly carries with it the limited authority to enter a dwelling in which the suspect lives when there's reason to believe the suspect is within. Close quote. Bill Shipley again, but Payton had to take note of and accept the doctrine of exigent circumstances that the Supreme Court had adopted in a series of cases with different facts that were deemed to be exceptions to the warrant requirement of the Fourth Amendment. And that's like the case of the Supreme Court case from 10 days ago, Case v. Montana. Those police entered the home without a warrant because of exigent circumstances. The person inside the home was reportedly threatening to kill himself, had a gun, had a suicide note, and that's what privileged those officers to enter without a warrant. Exigent circumstances. Bill goes on here. Exigent circumstances were first recognized as an exception to the Fourth Amendment in Johnson v. United States, Supreme Court decision decided in 1948. The Supreme Court declined to apply it in that case, however, based on a finding that the exigency didn't actually exist on the facts of that case. But in Warden v. Hayden, 1967, the court recognized hot pursuit as an exigency that excused noncompliance with the warrant requirement before entering a residence. In Michigan v. Tyler, 1978, the Supreme Court recognized as an exigency the emergency need to enter a residence to fight a fire, which then continued into investigating the cause of the fire without first seeking a warrant. In Brigham City v. Stewart, 2006, the court recognized emergency aid as an exigency that excused compliance with the warrant requirement before entering a residence. And only 7 years later, Justice Scalia wrote in a 5-4 decision in Griffith that we just looked at that no warrant was required to enter the residence of a criminal probationer due to the special needs of the probation program, and such entry could be made upon mere reasonable suspicion of a probation officer. No judge's determination of probable cause was required. Justice Stevens, the author of the Supreme Court decision of Payton, was a member of that Supreme Court, was a member of the Griffith Supreme Court. But he was now among the 4-justice minority in Griffith. In dissent, he wrote, the dissent, of course, is the losing argument in Payton, losing to Scalia, quote, mere speculation by a police officer that a probationer may have had contraband in his possession is not a constitutional sufficient basis for a warrantless, non-consensual search of a private home. I simply do not understand how 5 members of this Supreme Court can reach a contrary conclusion. Accordingly, I respectfully dissent, close quote. And Bill Shipley notes that is the totality of Stevens' dissent, every single word. I'm not sure that is an accurate characterization by Justice Stevens of what Justice Scalia had written in his majority opinion, but the carving of such a gaping hole in his a man's home in his castle pronouncement from the earlier Payton case, only 7 years earlier, had to sting a bit, so he can be forgiven. In my discussion of Abel above, I mentioned that there were 2 Supreme Court cases that dealt with the issue of Fourth Amendment in immigration matters. Abel was one. I wrote about the court's 1984 decision in INS v. Lopez Mendoza in my Substack article yesterday. In that article, I quoted Lopez Mendoza at length as it deals with the application of the exclusionary rule to deportation proceedings. Take a look if you don't believe me. Before going into the opinion again, it's worth noting that Lopez Mendoza, a 5-4 decision, was written by Justice O'Connor shortly after she replaced Justice Stewart on the court. The 6-3 outcome in Payton only 4 years earlier in 1980 had been Stevens, Brennan, Stewart, Marshall, Blackmun, and Powell, with Berger, White, and Rehnquist in dissent. The 5-4 outcome in Griffith in Wisconsin, Justice Scalia's opinion dispensing with the warrant requirement for probation services, was Scalia, Rehnquist, White, Powell, and O'Connor. Justice Powell switched sides, along with Scalia and O'Connor replacing Berger and Stewart. The dissenters were Marshall, Blackmun, Stevens, and Brennan, who had all been in the majority just a few years later with stricter Fourth Amendment rules. The 5-4 decision in INS v. Lopez Mendoza, which were in between Payton and Griffith, written by Justice O'Connor, was O'Connor, Berger, Rehnquist, Powell, Blackmun, with the dissenters, Stephen Brennan, Marshall, White. Over the course of those 7 years, the Supreme Court moved away from the liberal majorities of the Warren era into the conservative majorities of the Rehnquist era. As I noted in detail yesterday, Lopez Mendoza concerned, among other issues, the application of the exclusionary rule for Fourth Amendment violations to deportation proceedings, with the Supreme Court ultimately determining that the application was not warranted to address Fourth Amendment violations, the exclusionary rule. But here's the part of the opinion that really intrigues me in terms of how the Supreme Court now, today, in 2026, may wrestle with the issue of whether a judicial arrest warrant, Article 3 judicial arrest warrant, is needed to enter a residence to arrest an illegal alien with a final order of removal. So now we have a more conservative Supreme Court in 1984. And they said, quote, in Lopez Mendoza, quote, a deportation proceeding is a purely civil action to determine eligibility to remain in this country, not to punish an unlawful entry. The deportation hearing looks prospectively to the respondent's right to remain in the country in the future. Consistent with the civil nature of the proceeding, various protections that apply in the context of a criminal trial do not apply in a deportation hearing. The INS currently operates a deliberately simple deportation hearing system, streamlined to permit the quick resolution of very large numbers of deportation actions, and it's against this backdrop that the cost of the exclusionary rule, which you can read as full Fourth Amendment protections, must be assessed. The average immigration judge handles about 6 deportation hearings per day. Neither the hearing officers nor the attorneys participating in these hearings are likely to be well versed in the intricacies of Fourth Amendment law. Immigration officers apprehend over 1 million deportable aliens in this country every year. A single agent may arrest many illegal aliens every day. The officers cannot be expected to compile, elaborate, contemporaneous written reports detailing the circumstances of every arrest. By the way, this was 1984, Lopez Mendoza. Yes. Just as a side note, if immigration was arresting 1 million deportable aliens every year in 1984, do we not have to believe that my estimate of 90 million illegal third world migrants in America today is reasonable? 2026, a generation later. Anyway, Bill says, now consider again the language of Scalia in the later Griffith case. Quote, although we usually require that a search be undertaken only pursuant to a warrant and thus supported by probable cause, as the Constitution says warrants must be, we have permitted exceptions when special needs beyond the normal need for law enforcement make the warrant and probable cause requirement impracticable. Close quote. Bill Shipley continues, the nature of the task before ICE in enforcing immigration laws in the removal process in 2026 are vastly larger than was the task of INS in 1984 when Lopez Mendoza was decided. There are literally millions of illegal aliens residing in the interior of the United States, a problem not caused by the Trump administration, but one that belongs to the Trump administration to solve. The DHS policy of allowing warrantless entries into residences for the sole purpose of apprehending illegal aliens with no right to be in the United States when they lack any further due process rights, as reflected by a final order of removal, advances the congressionally created removal system intentionally designed to operate separate and apart from the criminal justice system process in the Article 3 courts. Remember, Congress took immigration matters away from the Article 3 courts and put them in dedicated Article 2 immigration courts. Bill continues, the Supreme Court has carved out a myriad of exceptions to the warrant requirement of the Fourth Amendment, even in the criminal justice context. Requiring judicial arrest warrants based on probable cause as found by a neutral magistrate would throw into the courts the need to obtain potentially millions of such arrest warrants. And what probable cause would be required for such illegal aliens beyond the existence of a valid final order of removal? What exactly is advanced by the procedural step of requiring an ICE officer to show the final order of removal to an Article 3 judge simply to get the Article 3 judge's signature on a judicial arrest warrant? This is a materially different circumstance than found in criminal investigations, where an individual is innocent until proven guilty, and the neutral magistrate serves as a buffer between the zealous law enforcement officer wanting to make the arrest or the search and the suspect who still enjoys all due process rights and the presumption of innocence. DHS ICE officers are sworn law enforcement officers. When in possession of a final order of removal, they have probable cause to show that the illegal alien named in the order has no legal right to remain in the United States. There is no purpose served by interposing an official of the judicial branch in the process, which has been designed by Congress to minimize the involvement of Article 3 courts. I'll end, Bill writes, with the words of Justice O'Connor and Lopez Medina. I said Menendez. Sorry about that. Lopez Medina, in justifying the non-application of the exclusionary rule, the Fourth Amendment, to remedy Fourth Amendment violations in the enforcement of immigration law. Quote, from the Supreme Court, Justice O'Connor, there comes a point at which courts, consistent with their duty to administer the law, cannot continue to create barriers to law enforcement in the pursuit of a supervisory role that is properly the duty of the executive and legislative branches, close quote. That glorious separation of powers that defends America from tyranny. Bill concludes that admonition to the judiciary is more obvious today, when the judiciary is far more overreaching and radicalized, than it was in 1984 when she wrote those words.